Court does call the case. People versus Sonia McLean. You got it? We clear in? On the, yeah, okay. All right.
You said, get first from the
Oh, hi. Sorry. Are you working?
Yes. All right. All discovery is complete.
That's the mission. May we approach?
This is B3.
There's no need to approach, well, Mr. Brown wants to approach you kind of, but, Mr. Brown has asked me, a couple of times for any videos in this case. I've sent, multiple emails to YPD requesting any audio or video. They've probably unresponded to. So there may or may, I don't know if there is any video or not, but my requests for any video have gone unanswered. I have no issue with setting it for a PE. If something turns up, we'll cross that bridge and we get there.
He can dismiss it.
Well, I realize is there a reason to believe that there is video?
Yeah.
Okay, and the people have, you requested, Mr. Brown, people have requested a YPD and they just have not.
They're ignoring it.
I'm used to that, but
I guess, Mr. Childers, to the extent that they're not, there's no response. Is that?
the response is not that there is no video, there's just no response.
Then if
I suppose if the court wishes, I could elevate my email to see if I email command staff, if they may respond, but no. It's certainly worth a shot. If we want, in an effort to keep the case moving along, I can stay out until the end of September, and I can continue my efforts.
well, I don't know why it's one thing if there's an issue getting discovery. This is a whole other realm
Yes.
where they're not responding to a legitimate discovery request. And, you know, and I'm not trying to disparage any department, but the last time I ran into this was with YPD. And I ultimately ended up dismissing the case. All right, here's what we'll do. She wants to say something with her law degree.
Yeah.
I don't think she does. The people around you are doing just fine. Okay. So here's what I'm going to do. I'm going to set so as not to impact the defendant's rights. I'm going to set the preliminary examination. Mr. Brown, prepare an order for my signature that directs that YPD is to turn over all video. I will set this examination for the 17th. Today's the 4th. So I'm going to need it right away so that there's time. But that they're to turn over all video to the Washington County Prosecutor's Office by the 11th. And if they then, that will go under my signature. That way, if they then fail to do what I'm ordering them to do, then the court will take appropriate remedies.
Your Honor, from a logistical standpoint, once that order is signed, would you like for me to send that order along to YPD?
Yes, please. Preliminary examination in this matter. will indicate discovery is not complete, but preliminary examination in this matter will be set in person September 17th, 2024, 9 a.m. That will be before me. And then bond will continue. Now, given all of that, ma'am, is there something you wanted to say?
She was trying to leave and go to the, get on the bus, and there was some contact, so we had to contact Pittsfield Police to make a narrative report that she was not in violation of any court orders. I have a copy of it if you'd like.
Hold on.
Just would like to be able to get on the bus.
Hold on. You gotta catch me up because that was today.
No, that was the last time.
22nd.
22nd.
Mr. Morgan, approach.
Just hold on. Okay, you're good. So, well, I just want to make sure I'm clear. You got on the bus. You were, okay, but in any event, you ended up on the bus, right? Okay. All right. Hey, but hold on, just hold on a moment, okay? And then at some point, the alleged victim in this case came into contact with her.
Yes.
As I'm to understand, based upon what you said, Mr. Brown, she then contacts the police.
She comes back here, asks for my advice. So
Got it. That's it. I don't want to know what you two discussed. But out of that, there then is generated a report from Pittsfield.
yes,
Got it. And so your concern, ma'am, is that somehow the court may try to hold you responsible for that conduct. Okay, I have not seen the report. I do not think that I need to see it. Okay. I'm going to make a presumption as to the advice that Mr. Brown gave you. I think that was absolutely appropriate advice. And should the issue arise, then I would review that report and I would take that all into consideration. All right. But at this point, I am not going to do anything. I don't have a complaint that you've done anything. And so I'm not going to make one. Fair enough?
I need time to get on the bus again. Not leave out of court and get.
Okay. All right. Listen, just listen. Mr. Brown gave you advice, okay, regarding a situation that you had, I guess, last time that you were here, right? So it would seem to me, would it not, that should you leave and that same or similar type of thing happen, that you would then follow the advice that your attorney gave you? And I kind of indicated to you at this point how I'm looking at it. Okay? I know it may worry you, but I think follow what your attorney is telling you. All right? Okay, anything else you want to yell at me about? Not what?
I don't want to have the same issue that happened last time I was here. And you asked Ms. Morgan to sit and wait for it. No.
Okay, hold on. Where is Miss Morgan here? Okay, you need to sit down.
Can I say something?
No. All right. So you need to get on the bus. Okay, stop for a moment. Miss Morgan, do you need to get on the bus?
Yeah, the bus had video, did nothing happen, I got off the bus.
Okay,
The bus had video, she's lying.
And I'm going to presume you both take the same bus.
I don't have a
Okay.
question.
I wish you would stop yelling up here at me. Mr. Feaster? I'm not going to ask you to drive anybody, so don't tell me. No, I'm just, so, okay, here's the thing I do not know. And I'm going to maybe potentially embarrass myself. I have not taken a bus. Well, no, I don't. Wow. But I just haven't. And so I know that when I get on a bus, or when I did, but is so long, the dinosaur was pulling it. But anyway, it just took me downtown, and then I had to find another bus. And I just told myself I'm not doing all that. So that's why it's my limitation. How often do the buses come to where you would have to pick the bus up, get the bus?
Every 15 minutes across the street.
Every 15 minutes across the street. Okay, so here's what we're gonna do. Okay? This time around, you get the first 15 minutes. Remind me the next time, then you'll get the first 15 minutes, and then you gotta wait and take the next bus. Huh? Oh, so now you took up all my time, now you wanna leave? No, go, just go. That's what we're gonna do. You go, don't get up, Miss Morgan, do not get on that same bus. Do not get on that. That's fine. I don't want you both on that same bus.
Still approaching me and sending threats to me, Your Honor, and that is the process.
Then you report that to the prosecutor's office. They will raise.
I told him again.
Don't know how to change it, right? Okay, so I will just say this, Ms. Morgan, when it is raised before me in a proper way by the people, I will deal with it, much like I said I would deal with her issue. But right now, I want you to take the next bus. The next time around, you'll get the first shot at the bus. She'll wait. Thank you.
This court hearing involved the case of People versus Sonia Milan, focusing primarily on discovery issues, alleged contact between the defendant and the complainant, and ensuring the defendant's rights were protected while the case moved forward. Defense counsel, Mr. Brown, informed the court that discovery was largely complete except for a critical issue. Despite multiple emails sent to the police department, there had been no response regarding whether any audio or video recordings existed in the case. The prosecution acknowledged that requests had been made to the police department, but no confirmation had been received as to whether video evidence actually existed. The judge expressed concern that failure to respond to legitimate discovery requests, particularly regarding possible video evidence, was unacceptable and noted prior experiences where similar noncompliance had led to serious consequences, including dismissal. To avoid prejudice to the defendant and keep the case moving, the judge ordered that a preliminary examination be set and directed Mr. Brown to prepare an order, requiring the police department to turn over all video evidence, if any exists, to the Washtenaw County Prosecutor's Office by September 11, 2024. The preliminary examination was scheduled for September 17, 2024 at 9 a.m., to be held in person before the same judge, with bond continuing unchanged. The defendant then raised a concern about a prior incident involving public transportation, explaining that during a previous court date she attempted to get on a bus, during which there was brief incidental contact with the alleged victim, prompting police involvement solely to document that she was not in violation of any court order. The judge carefully clarified the timeline and circumstances, emphasized that no complaint had been filed against the defendant, and made clear that the court was not accusing her of wrongdoing. The judge stated that he had not reviewed the police report, did not believe it was necessary at that point, and expressed confidence that defense counsel had given appropriate advice. He explained that if the issue were ever formally raised by the prosecution, the court would review the matter properly and consider all facts before taking any action. The judge reassured the defendant that she was not currently in trouble and advised her to continue following her attorney's guidance. Toward the end of the hearing, the judge addressed logistical concerns related to both parties using the same bus route, expressing frustration with the tension but offering a practical solution. The defendant would take the next bus rather than the immediate one to avoid contact, and future situations would be handled fairly by alternating priority if needed. The judge made it clear that he did not want the parties on the same bus at the same time, and that any future issues should be reported through proper legal channels rather than handled emotionally. The hearing concluded with the court reiterating that any alleged violations would only be addressed if properly brought before the court by the prosecution, and the parties thanked the judge as the matter was adjourned with clear instructions and expectations moving forward.
Good morning, this is Melissa Warren, hearing the from here. State your name, please.
Manuel Ramirez.
Thank you.
Now, we are here for a pretrial and there's also a bond violation.
Yes.
The reason being because he did not go to community corrections as ordered after his arraignment. I did speak with him about it, and he stated that he was confused. He didn't realize he needed to go. He said that he was trying to pay attention to what Your Honor was saying. He was nervous. He heard the last thing that came out of your mouth, which was the next court date, and that's kind of all he remembered as his arraignment was finished. We did speak about the warrant dictal and the warrant recall. He did not put himself in because he's in school. He's at Washington Community College. But he is here. He does want to address the warrant today. He is willing to go test right now. And he believes he can come back clean. And he's asking for warrant to be recalled and another referral to be made to community corrections so he can get back.
Cancel the bench warrant that's out over in state previous bond. Defendants to report before he leaves this facility to community corrections for placement on a scram tether this time. So we don't have an issue. All right. And then I'll adjourn this out. How much time did you need?
I think the 18th should be okay, Your Honor.
I'll adjourn this to September 18th, 2024, 9 a.m. You understand that, sir?
Yes.
You need to get over to community correction. All right. Thank you.
Consider it split G as all way. The election is 2.206.
Sir, if I give you a test that's going to detect alcohol, whether or not you consumed alcohol recently, are you going to pass that test?
I'm pretty sure.
Why aren't you absolutely sure, Mr. Allen?
Because I don't drink alcohol.
What do you mean you don't drink alcohol?
Stay away from anything that's gonna get me in trouble. I'm just trying to fix everything, you know. I'm just trying to get back in order, you know.
When's the last time you drank?
Probably like 2 years ago. Like somewhere right there.
Well, that can't be true.
Probably like. Well, I just haven't been drinking, you know. I don't drink anymore.
All right, I'm gonna try this again. When was the last time you had something to drink?
Something to drink this morning, coffee.
I mean, alcohol.
Oh, that's funny.
Okay, probably like 12 months ago, maybe, somewhat, can't remember, but, 12 months ago, let's say.
So you haven't consumed any alcohol for the last 12 months?
Probably mouthwash, something that,
Council approach. Okay, so here's what I'm gonna do. Sir, I need straight answers to my questions. So I'm gonna give council an opportunity to talk to you about how you address the court and answer the court's questions. So, Mr. Allen, if you could have him have a seat over here, and Ms. Parity will get to you as soon as possible, and we'll see where we go from here.
Morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Ramirez. Mr. Ramirez, again, from the record, please state your name.
Manuel Ramirez.
So remember, I didn't have a chance to speak to my client. We did speak about the answers to your questions and how it's important to give straight answers. I think he's quite nervous, and I think that impacts his demeanor here today. But again, I emphasize that the court wants straight answers. Regarding his drinking, he does think that he's going to pass. He indicated he has not used any drugs, marijuana, or alcohol. He believes that the last time he drank was around the time of this offense, and hasn't used anything since.
Is that right?
Yes.
Just send him over. He's gonna be put on a scram unit. I also want. You haven't used any drugs? ETG, and I want a urine test on him also. So when he goes over, I want a one-time drug test. And then if he's positive for anything, it's gonna continue weekly. And then also an ETG, and he's gonna be placed on a scram tether.
Would you like him to come back after his test, or?
No,
Okay,
we'll catch up to him.
all right.
Thank you.
Thank you.
Fine to continue at this time.
Thank you.
Okay, so the people versus Thomas Hornberger.
That's a lot of people.
Good morning, Your Honor. Robert Owen, with on behalf of Mr. Hornberger. Mr. Hornberger, can you please state your name?
My name is Thomas Warrenberg.
Thank you, sir.
Your Honor, today's date and time set for pre-trial in this matter. After speaking with Mr. Hornberger, he has informed me that he wishes me to be removed from the case and be appointed new counsel.
What's the problem?
I just don't have a lot of confidence. It doesn't appear to me that he's optimistic or has enough confidence for me to feel comfortable.
I'm not sure what that means. Sometimes attorneys aren't very optimistic. Okay, all right. I mean, sometimes they're dealing with reality of what you might be up against. And so what you really want is an attorney that's gonna like give you the cold hard truth.
Yes, sir. I understand that.
Okay, you got me?
Yes, sir.
And I've known Mr. Ellman. I don't think you're going to do better, but
I don't know. I just feel like I'd rather have someone else.
well,
It's nothing personal. I mean, he's a
No.
nice guy, but I mean, he's a very
He
nice
is.
guy. We have a good rapport. We get along well. I just feel that he just doesn't seem to have enough. It's just not positive and confidence enough.
well, I got you, but you
I
don't,
do understand what you're saying.
no, I got you.
Your
Okay.
Honor, if I could put it on the record, just I don't know if this makes things easier or not, I wouldn't object to being removed from the case. If Mr. Hornberger doesn't have faith in what I'm telling him, I have no objection, if that makes your decision easier.
No. But nice try. You don't get to pick your attorney because you're appointed on this.
Correct.
And so that's not how the choices are made. There has to be a basis upon which I would remove an attorney from a case, sir. That's not a sufficient basis that you've given me. All right. So what I'll do, Mr. Elman, if you want to file a motion or do whatever, then you can. I'll adjourn it out for that to happen. But if that's the basis for it.
Could we pass the matter? I'll talk with Mr. Hornberger and figure out what he wants to do moving forward, and then if you could recall
it. Fine, Mr. Elman, I'll recall it. All right, I'll pass it so you two can chat a little bit, all right?
I appreciate it.
All right.
This court proceeding addressed both a pretrial conference and a bond violation after the defendant failed to report to community corrections following his arraignment as originally ordered by the court. Defense counsel explained that the defendant claimed confusion and nervousness during the arraignment, stating that he only remembered the next court date and did not fully understand that he was required to immediately report for supervision, although a bench warrant had been issued. As a result, the defendant appeared voluntarily in court and expressed willingness to comply, including submitting to testing right away. The judge emphasized accountability and ordered the defendant to report to community corrections before leaving the courthouse, placing him on a SCRAM alcohol monitoring tether to ensure compliance going forward, and adjourned the matter to September 18, 2024. During questioning, the defendant gave inconsistent and unclear answers regarding alcohol use, initially claiming he had not consumed alcohol in years before revising his statements, prompting the judge to pause proceedings and allow defense counsel to privately speak with him about the importance of providing direct and truthful responses. After consultation, counsel clarified that the defendant believed his last alcohol use occurred around the time of the alleged offense and that he had not consumed drugs or alcohol since. The court then ordered immediate ETG alcohol testing, a urine drug screen, and continued SCRM monitoring, warning that any positive results would result in ongoing weekly testing. The judge made clear that honesty and strict compliance were now essential if the defendant wished to remain out of custody. The hearing then moved to another case involving Mr. Hornberger, who requested new court-appointed counsel, stating he lacked confidence in his current attorney and felt the representation was overly pessimistic. The judge explained that court-appointed attorneys cannot be changed simply based on personal preference or perceived negativity, stressing that effective legal representation often involves giving difficult but realistic advice. The attorney indicated he would not object to withdrawal if the court allowed it, but the judge ruled that dissatisfaction alone was not sufficient grounds for replacement and instructed counsel to discuss the matter further with his client before any formal motion could be considered. The case was temporarily passed to allow that discussion to take place. Overall, the session highlighted the court's focus on compliance with bond conditions, the importance of clear communication between defendants and counsel and the judges, firm stance that supervision requirements, testing orders, and attorney assignments must be respected to protect both the integrity of the legal process and public safety.